Gun owners buckle up, because the Supreme Court just dropped a decision that didn't tweak gun laws or adjust a few rules. It straight up vaporized half the restrictions states have been leaning on for years. I spent the whole night digging through the ruling, the lower court reactions, and the case is already getting flipped because of it, and the fallout is way bigger than people think. I'm Ted from Line 45. And this one matters because what the court just did is about to change how every single one of us carries, buys, and defends our rights in real life. Before we dive in, do me a solid. Smash that subscribe, tap the bell, hit all the dang buttons down there. You don't gotta, but it keeps this train rolling, and lets me crank out more of this wild gun talk for y'all. All right, enough of that. Let's get back to it. The ruling that blew everything up. When people say the court changed everything on guns, this is the case they are talking about. In 2022, in New York State Rifle and Pistol Association versus Bruen, a 6-3 majority took New York's concealed carry law and used it as the test case to rewrite how gun laws get judged. Here is what the court actually did. Before Bruen, lower courts used a two-step balancing test, where they asked if a law hit the core of the Second Amendment, then weighed it against public safety interests. Bruen threw that out and replaced it with one question. If the plain text of the Second Amendment covers what you are trying to do, the government now has to prove that its restriction lines up with this country's historical tradition of firearm regulation from the founding era. If there is no historical analog, the law is in trouble. That sounds academic, but the fallout is real. New York's proper cause rule, where you had to show a special need to carry, was struck down because self-defense in public is now treated as a protected use. States like New Jersey, California, Hawaii, and others with similar may-issue setups were suddenly on notice, and a lot of those policies started getting revised or challenged the same week. Since then, every Second Amendment case in federal court has to run through this history and tradition filter. Judges are digging into 18th and 19th century laws. Gun rights groups are filing suits on everything from age limits to carry zones, and states are scrambling to find any historical support they can. That is why I say this ruling cracked the system open and set the stage for half the gun laws to get dragged into court for real. Permit systems just got wrecked. Permit systems are where you really see Bruen bite. Before this, states like New York, New Jersey, California, Maryland, and Hawaii all ran these may-issue setups, where you could check every box, pass a background check, be clean as a whistle, and still get denied because some official decided you didn't have a special need. I look at that and go, yeah, that is exactly what the court was aiming at when it said the right to carry in public is covered by the Second Amendment. Under Bruen, once the court said ordinary, law-abiding citizens have a right to carry for self-defense, those discretionary systems had a target on their back. The opinion flatly called New York's proper cause rule unconstitutional because it flipped the burden. You had to prove to the government why you deserved the right, instead of the government having to justify why it was limiting it. After that ruling, you saw states rush out Bruen response, bills trying to convert to shall issue, where if you meet objective criteria, they basically have to issue the permit. Some tried to sneak in long reference checks, in-person interviews, social media reviews, stuff like that. Courts are already hammering those when they get abusive or open-ended. One more thing I watch closely is the delay. Bruen did not give a hard number of days, but lower courts picked up the line that a right delayed is a right denied and started slapping states that drag their feet. You have cases where people waited months past statutory deadlines, and judges said that kind of foot-dragging is a constitutional problem, not just bad customer service. So when we talk about permit systems getting wrecked, it is not hype. The move from may issue to true shall issue, with real timelines and objective requirements, is happening on paper, in court orders, and in day-to-day carry practice across the country. States can't pile on hoops no more. Training and hoops are the quiet part of gun control that a lot of folks miss, and that is where I pay close attention. Bruen actually name-dropped training and fees when it talked about shall-issue permits. And the court basically said, look, objective stuff like background checks, fingerprints, and a basic course can fly. But states do not get a free pass to turn that into a slow, expensive obstacle course. The opinion warned about long wait times and exorbitant fees being used to choke off the right, and that line is exactly what lawyers are using now in these new cases. When I look at what New York and New Jersey did after Bruen, you can see the pattern. New York CCIA dropped an 18-hour training requirement with live fire, character references, in-person interviews, and more. Federal judges in cases like Antonyuk versus Hochul and related challenges have been picking that apart, upholding some parts for now but calling out the risk when requirements get too heavy or too subjective. Same story in New Jersey in Coons v. Platkin, where the court let certain training stand but flagged the state's whole response package as likely overreaching in other areas. Courts are not saying no training at all. They are saying keep it basic, keep it affordable, and do not use it as a backdoor ban. So when a state stacks multi-day classes, high costs, renewals, interviews, and prove your worthiness on top, I see judges step in and say, that is moving away from an objective, historical-style regulation and into pure deterrence. Under this new Bruen test, that kind of setup is living on borrowed time. Bans on Rs and mags are falling apart. On the hot-button side, this is where AR bans and mag limits run straight into the Bruen wall. Heller already said the Second Amendment protects arms in common use by law-abiding citizens, and later opinions and lower courts have pointed out that the AR-15 is the most popular semi-auto rifle in the country, with tens of millions in circulation and standard mags of over 10 rounds all over the civilian market, no cap. When I look at California, it is basically ground zero for this fight. In Miller v. Bonta, Judge Benitez has twice held that the state's assault weapon ban violates the Second Amendment and pointed to the common use of these rifles for lawful purposes. The Ninth Circuit has kept that decision stayed, so the ban still applies while the appeal runs. On the magazine side, Duncan versus Bonta is the mirror image. An en banc Ninth Circuit panel recently upheld California's 10-round limit under Bruen, and gun rights groups have already pushed a cert petition up to the Supreme Court. Outside California, the story is split. Maryland's ban on AR-15-style rifles was upheld en banc in Bianchi v. Brown, with the court saying these guns fall into a category of excessively dangerous weapons that states can regulate, even under Bruen's test. In Illinois, the statewide ban and local rules in cases like Bevis and later Viramontes have mostly survived at the appellate level, and the Supreme Court has turned away emergency bids to freeze those laws, even while at least one district judge has called the ban inconsistent with the Second Amendment. So here is how I read it. Bruen gave gun owners a very strong common use plus history framework, and you can see district judges using that to knock these bans down. At the same time, some circuits are trying to salvage them by leaning hard on dangerous and unusual history. That split is exactly why I say these AR and mag bans are on unstable ground long-term. One clean Supreme Court ruling on this specific issue would either lock them in or blow a big chunk of them out, for real. Gun-free zones are getting shredded. Sensitive places is the phrase that tells you how aggressive a state got after Bruen. After the court said you cannot use may issue to choke carry, states like New York, New Jersey, and Hawaii tried a new play, declare huge chunks of public life sensitive, so carry is basically banned again. I look at those maps and think, yeah, that is exactly what the justices warned about when they said you cannot turn whole cities into gun-free zones. New York's CCIA lists around 20 categories of sensitive locations. That included parks, public transit, Times Square, houses of worship, and then a separate rule that treated all private property as off-limits, unless the owner posted a guns allowed sign. Federal judges in Antonyuk and related cases hit a bunch of those. The Second Circuit eventually let some sensitive places stand, like mass transit and houses of worship with security carve-outs, but it was not willing to bless every broad category the state wanted. New Jersey copied a lot of that in its carry law and ran into the same wall. In Coons versus Platkin, the district court said several of the new sensitive place bans were plainly unconstitutional and enjoined big pieces of the list, including the default ban on carry in vehicles and on most private property open to the public. The Third Circuit later adjusted that mix but kept pressure on the state to tie each spot to real historical analogs. Hawaii went even harder on the private property default rule in sensitive locations, and the Ninth Circuit in Woolford v. Lopez upheld some pieces, but agreed that trying to label almost all public areas or all businesses as sensitive goes too far. The Supreme Court has now taken Woolford specifically to review that private property rule. That tells me the justices know this is the new front line. If a state wants to fence off a place today, it has to point to something similar from the 18th or 19th century. Broad, everywhere people gather, bans are getting sliced up in court, and that trend is only moving in one direction, no cap. What is going to collapse next? Here is how I see the next few years shaking out, just looking at what is already in the courts right now. Age limits are front and center. The Fifth Circuit, in cases like Firearms Policy Coalition versus McCraw and related challenges, has signaled that flat bans on 18 to 20-year-olds carrying or buying certain long guns do not match the historical record, since young adults were part of the militia and expected to be armed. Other circuits are more hesitant, so that split is growing. Once the Supreme Court takes a clean age case, a lot of 21 and up only rules for carry and rifle purchases are going to get a serious stress test, no cap. Roster-style laws and tech mandates are another weak spot. California's handgun roster got hammered in Bruen versus Bonta, where a federal judge said the state's micro-stamping and loaded chamber indicator requirements had no real founding-era analog and kicked modern models off the market in a way that does not line up with the Second Amendment. The same vibe shows up in challenges to California's ammunition background check system, where a district court already found the system blocked huge numbers of lawful buyers while catching almost no prohibited persons. Once those questions get to the appellate level, under a pure history and tradition test, I do not see a long shelf life. Waiting periods, public transport bans, and prove your need restrictions on where you travel with a gun are in that same danger zone. The more modern and paperwork-heavy a rule is, and the less it resembles an 18th or 19th century law, the more judges are side-eyeing it under Bruen. That is why I keep saying the big quake already happened. What we are watching now are the aftershocks hitting every modern gun control idea that grew up in the last 50 to 70 years.